proceed to hear argument in the last case on the calendar, which is 21-16756, Todd Yukutake and David Kikukawa versus Lopez. And this time we will hear first from Mr. Nakatsuji.
Good morning again, Your Honors, and as you know, my name is Robert Nakatsuji. I'm the First Deputy Solicitor General for the State of Hawaii, and I represent the defendant appellant, Hawaii's Attorney General. I would like to reserve 5 minutes for rebuttal, if I may. May it please the Court. Your Honor, similar to the last case, I would again like to renew our request for remand to the District Court. The motions panel denied our original request and ordered supplemental briefing, but again, Your Honor, I'd like to point out that the supplemental briefs really touch the tip of the iceberg. There's very extensive historical analysis involved in this issue, and basically what happened in the lower court and the original appellate briefs are largely obsolete as a result of Bruin, and that leaves basically the supplemental briefs for this court to make some very important decisions. So again, I would ask the court to consider remanding. If this court does not want to remand, on the merits, this case addresses the constitutionality of two provisions of Hawaii law. One is the 10-day deadline for permits to acquire handguns to be used. The second is the requirement of in-person inspection of firearms at the time of registration. And our position is that both provisions are constitutional. Now, we argue, Your Honor, that there are three historical analogs to the challenge provisions: militia laws, loyalty oaths, and pardons. Militia laws, while militia laws are an affirmative mandate to obtain a weapon, implicit within that mandate is government permission to possess the weapon. Furthermore, Your Honor, militia laws provided for inspection of firearms. The government officials would inspect the firearms. The results of that inspection would be written down, and that was an early form of registration.
Starting with the 10-day permit provision, what purposes does the permit serve apart from background checks? I assume background check is part of the permitting process. What other purposes are served by the permit other than the background check?
Well, Your Honor, the permit ensures that the person is in compliance with Hawaii law. So they pass a background check, you gain this basic information about the person, and the
Are there two background checks? If they buy from an FFL, do they go through two? They go through one in the permit process, and then they take the permit to the FFL, and they go through another one at the point of sale?
I am not entirely sure, Your Honor, but I believe the way it works is in buying the gun, the permit is, I believe, the person goes to the firearms dealer, and then I think the firearms dealer checks with the local officials, and I think the local officials do the actual background check. I don't know the details for sure, Your Honor, but it happens during that process.
The federal check that's done by the FFL, right? I mean, that's going to occur no matter what. So
I believe it is done, Your Honor, but I believe also the state records are checked as well. And I think that's all part of the process. I don't know the details on this, Your Honor, but I believe that these are done as part of the process.
Just going back to Judge Collins' question, I mean, what is really the purpose of giving only 10 days after getting the permit to buy your gun? Because at this point, the permit, they've done the background check, so make sure they're not a felon. They've given access to mental health records to make sure there aren't any red flags. They've undergone their trainings to make sure they can use their firearm. So that's all done, the permit issues. I mean, what purpose is there to say you have to buy the gun within 10 days after that, or you can't? I mean, I don't understand what the purpose of that is.
Your Honor, the 10 days is there to ensure that that information remains accurate when the gun is actually purchased. There are situations.
That seems awfully short, 10 days. I understand some of the ripeness, but 10 days seems
Yes.
intended more to inconvenience people rather than make sure it's still valid.
Your Honor, the 10 days is there to ensure that it's valid, because if you have a longer period, there's a greater chance of intervening life events happening. The person actually becomes disqualified, but they still have a valid permit to go buy a weapon.
I mean, is there any mechanism within that 10 days that the state would know? If someone says, all right, they go through the background check, then the next day or 2 days later, person's indicted for, some
That's the
narcotic.
problem, Your Honor. I mean, it's based on self-reporting, so if you have a longer period, chances are really good that somebody will be disqualified and nobody will know about it. Whereas if you have a shorter deadline, the permit will expire naturally. And so when it expires, the person has to apply for another permit, and then the change will be reflected in the renewed license, the second appliation.
It seems like there's no real mechanism, even within that 10 days, for the state to figure out that person was qualified at day 1, but then undisqualified in day 10.
I think the 10 days is short enough where you don't need that. But if it were for a longer period, like some states have permits that are good for 5 years. During 5
And
years.
Hawaii has one for 1 year for long arms. Right?
Yes.
Which suggests.
So a
they think
longer
1 year is
period,
fine.
the risk is greater that somebody's going to get disqualified. You're not going to find out about it unless the person discloses, which is hard to assume will happen.
Is there anything in the statute that allows someone to get an extension?
I don't believe so, Your Honor. I think you simply have to use it within 10 days. If you don't use it, you reapply. But again, if there are changes in your circumstances, it will show up when you reapply.
So suppose someone, again, gets a permit, background check, mental health records, gets a training, gets a permit, has 10 days. It's going to go buy it on day 5, and then day 5 tests positive for COVID, has to isolate. So in that case, the person just has to go through the process all over again?
Yes, Your Honor, the person has to reapply. But, Your Honor, if you look at the statistics, 96% of people complete the purchase. It's only about 1 or 2% that doesn't do it within the 10 days. And then there's another 1 or 2% that ends up being disqualified. And that's, of course, the reason why you're doing this. You're trying to find the people who get disqualified. So,
of the regulation is to ensure that the information about being qualified to purchase a firearm is not stale. Why is it 1 year for much more dangerous long run?
Your Honor, I think when the law was passed, I think long guns were regarded as less dangerous. They were primarily considered hunting or target shooting weapons. So I think the danger was handguns because they're concealable. Maybe it's time to change that, but that is what the Hawaii legislature decided. And so long guns were allowed for 1 year and multiple purchases. This approach, Your Honor, is something that's not unusual. Lots of states have either short single-use permits, or they have longer-term but multiple-use permits. So it's a different kind of approach.
It's a private sale, not through an FFL, of a long gun. And is the background check for that could be a year old?
Yes, possibly, Your Honor. But again, the reason why we have a short deadline for handguns is so that the information isn't stale. It's at worst, it's 10 days old. So again, that's the reason why we have this. And Your Honor, part of the standard in Bruin is whether it's for an abusive purpose. And these purposes are not abusive. We're having these requirements for good reason. And, if you apply...
Counsel, good reason doesn't seem to cut the mustard with the Supreme Court. What they want is historical analysis and text. So tell me, is there any evidence here of other of 10-day waiting periods in colonial times or at the time of the adoption of the 14th Amendment?
Your Honor, we've traced back the 10-day limit to about the 1920s and 30s. But, Your Honor, I think you have to consider that this 10-day deadline, it's really an administrative enforcement procedure. It really is not geared toward the real purpose of the permit to acquire. It's really just an implementing procedure. And there is some authority for treating these secondary procedures differently. Bruin itself says that fingerprinting, background checks, training programs, they're okay, as long as the purpose of the regulation is to ensure that only the law-abiding responsible citizens have guns.
Measure that then, I know in general, Bruin rejects balancing, but if we're in a footnote 9 inquiry, where we're trying to assess whether or not, the measures that are adopted to implement the ban against prohibited persons that's historically based, what test do we use for that? Is that a means ends test, similar to time, place, and manner in the First Amendment context?
No, Your Honor, means ends is gone, but footnote 9 sets the standard. Footnote 9 says the regulations have to be narrow and objective, and they cannot be for an abusive purpose.
But footnote 9 cites First Amendment permitting cases, Shuttlesworth and Cantwell, and so can we look by analogy to First Amendment cases, because there's permitting cases in the First Amendment context, and we apply both time, place, and manner, and then specific regulations about discretion, time limits, etc. Would those kinds of similar doctrines carry over under footnote 9 so that we would look at a similar type of inquiry here?
Your Honor, that would be a very creative approach. If this court wants to explore that, I think that's a possibility. But I think our law will survive that, because I think...
Well, but what it ironically would land in, time, place, and manner in the First Amendment context lands you back in intermediate scrutiny, which is exactly where the district court started.
Yeah, I understand that, Your Honor. So it could be that this reference to First Amendment really is just talking about discretion, because under the prior restraint doctrine, discretion is a problem. So they could be simply referring to the lack of discretion.
They're also talking about, its abusive ends, lengthy wait times, exorbitant fees. So they're talking about burdens. And so we're looking at burdens and justifications. And so hence my question about the analogy to the First Amendment context.
Your Honor, again, these are very difficult questions, and perhaps remanding to the district court to consider all the ramifications may be a good idea. If not, the footnote 9 sets the standard. Narrow, objective, no abusive purpose. And I think our law satisfies those requirements.
Can I shift you for a minute now to the other one, to the 5-day in person?
Yes, Your Honor.
Because here, I think you're not quite in footnote 9, because I don't see that it ties at all to the prohibited person category. Because the 5-day in person has nothing to do with whether the person is a prohibited person. At that point, they already are. They've gone through the permit requirement. They got the permit. They showed up within 10 days. They had another instantaneous check if they went to an FFL. They have the firearm, not a prohibited person. Now they have to come in and show it. So this is not tied to prohibited person. What is it tied to? What is the purpose, and what is the how and why that ties in historically on the second one?
Well, Your Honor, the purpose of the inspection is, for one thing, to ensure that the serial number is properly legible, permanent, and accurate.
And why is the serial, what is the interest that is furthered by the requirement of the serial number and recording it and reporting it that's tied to a historical category under Bruin?
Well, Your Honor, the serial number allows you to trace the weapon, and it allows you to tie the weapon to a person who is either a law-abiding responsible citizen or is not. So it does ultimately go back to the person. The person has to be law-abiding and responsible. And as far as historically, Your Honor, again, Bruin, it says that certain procedures are okay, fingerprinting, background checks, that kind of thing. And this is another one of those procedural mechanisms. It's part of the registration process.
It have to be 5 days. Even if you want to say in person, we've got to see it because we don't really know unless we see the number. What's the justification for 5 days as opposed to 30 or as opposed to even 6 months. The 5-day immediacy seems odd.
Well, Your Honor, the 5-day is there to ensure that the registration happens in 5 days. And I think it's there because not everybody is going to be subject to a permit to acquire. People coming from out of state, they've already got the weapon. And so they need to register it within 5 days of arriving. And so I think that is why you're having this requirement to ensure that somebody is aware of the weapon, that the records are recorded.
Someone who just purchased a weapon in Hawaii, we've already, if they've bought from an FFL, we've put them through 2 background checks. They've cleared both of those. They've been given the firearm. The registration number has in fact been reported by the seller if it's an FFL. And this is just a triple checking on the number, and it has to be in 5 days, and what justifies that burden?
Well, Your Honor, the registration requirement is there, I think, because, again, there are some people who are not going to be covered by the permit to acquire. There's also other people in private transaction.
Again, you're changing I'm talking about the people who bought weapons in Hawaii. Why is it, what state interest is furthered by having them come in 5 days and not some other time period?
Well,
I
again,
understand the 10 days, the staleness, but I don't understand why it's got to be immediately. We must see that number right away, and what interest furthers that?
Your Honor, I think it's, again, to make sure that the weapon itself is consistent with Hawaii law. The permitting focuses on the individual, and that's all well and good, but an individual may come with a weapon that has something that's illegal on it, and the inspection will reveal that. There are things in Hawaii law that are illegal, bump stocks, barrel length. You can't have a weapon of a certain barrel length because then it's a sawed-off shotgun. Bump stocks, silencers, that kind of thing. And so you're inspecting to see if the weapon is compliant with Hawaii law along with any other attachments it might have or modifications. And so I think that's the urgency. But again, Your Honor, talking about the inspection itself, that's the reason why we have the inspection.
I'll ask another question about the registration requirement and the various versions of the law. As I understand the current version that's temporarily in place, anyone who buys their firearm from an FFL is exempt from the registration in-person requirement. Am I reading that correctly?
Yes, Your Honor.
Was that true under the version that was in effect from 2020 to 2022 as well?
I believe it was.
Because there's that language, you read the language and it looks like it could be read that the weapons that are obtained by the FFL don't have to be registered when the FFL takes them. But you could also read it as meaning anything that's sold by the FFL doesn't have to. The current law seems clear to carve them out, but I'm trying to figure out on that interim version.
I believe that if the weapon was registered by a dealer, it did not have to be inspected. I think it was everybody else.
When it's sold to a Hawaii citizen?
If it was the dealer who was registering it, I think it did not have to be inspected.
Okay, even under the 322 version?
I believe so.
Okay,
Your Honor.
that's helpful.
But again, the reason why non-dealers were required to be inspected was very often non-dealers aren't familiar with Hawaii law. So if you have a private transaction, they may be transferring a weapon that's actually illegal, and so the inspection was there to catch that. And again, Your Honor, we think there's a historical basis for that. The militia laws required inspection of weapons, and back then, there were militia officials inspecting, but fundamentally, they're doing the same thing. You're inspecting to ensure that it's in compliance with the law. The law required militia members to have certain kinds of weapons and certain kinds of equipment. Today, we're inspecting to ensure that other types of laws are in compliance with the weapon. Again, bump stocks, barrel length, etc. So it's the same idea, and it stretches back to the founding era. So basically, Your Honor, we have two theories. You can look at the direct historical analogs, militia laws, pardons, loyalty oaths. If you do not want to look at those analogs, we have footnote 9 of Bruin. Footnote 9 of Bruin says that if your regulation is geared toward ensuring that the law-abiding responsible citizens have guns and the criminals and the mentally ill do not, well, you can have other procedures, fingerprinting, background checks, and our procedures here are similar to those. I think, Your Honor, you have to be careful to make a distinction between the secondary procedures and the underlying basis. And I think if you too closely scrutinize the secondary procedures, for one thing, it's inconsistent with Bruin, because Bruin just categorically says fingerprinting, background checks, it's okay. But, if you subject every single procedure to a historical analysis, a lot of them are going to fail. Fingerprinting, for instance, which Bruin cites, fingerprinting didn't exist until the late 19th century, wasn't adopted until the early 20th century. So a lot of these procedures don't have historical analogs, but Bruin doesn't require historical analogs for these procedures. Another example, Social Security numbers. It's very common to require Social Security numbers for firearm applications. Social Security numbers didn't exist until 1935 when the Social Security Act was passed. Telephone numbers. Very common to require a telephone number. Telephones weren't invented until the late 19th century. So you have to make this distinction between the secondary procedures, which are implementing the underlying idea that guns should be limited to the law-abiding responsible citizens. If you don't make that distinction, then you're going to be striking down all kinds of procedures which really make a lot of sense in the modern world, and you don't have to. Bruin doesn't require striking down a lot of these procedures. And I would argue our procedures here fall in that category. They are implementing procedures. They don't have to comply with that very strict historical pedigree. Again, Your Honor, there's a certain amount of flexibility built into Bruin.
All right. Thank you, counsel.
Thank you, Your Honor.
And we'll hear
Good morning, Your Honors. My name is Alan Beck. I'm counsel for the plaintiff appellants. The matter before this court is addressed by my friend on the other side, are two of Hawaii's registration laws. In Bruin, the Supreme Court very clearly stated that it is the burdens on the government to affirmatively demonstrate that there is a historical parallel to the laws at issue.
Is that clear when we're talking about the footnote 9 situation? Because the permitting requirement, it is a tool to ensure that the historically grounded prohibited persons category is being accomplished using modern technology. Background checks were impossible just because communications in general was so poor previously. But now that it's possible to do instantaneous verifications or very rapid verifications of whether someone is a prohibited person, that is now a tool to enforce that historically grounded category. What is the standards, as you understand it, under Bruin and footnote 9 for evaluating those kinds of measures to implement that historically based prohibited persons category?
Yes, Your Honor. I'm not suggesting that something that like instantaneous background check, like the NICS system, is something that should be struck post-Bruin. And again, I would go to the how and why of why something is in place. There absolutely were laws that prohibited felons and other categories of
people. Isn't that what this permitting regime does? It implements a background check. Now maybe it's duplicative with respect to those who then buy from an FFL, but for those who don't buy from an FFL, doesn't it ensure that there's a background check in connection with that purchase?
It's in the, we aren't, the permit to acquire, arguably the permit to acquire itself is doing that. And in this litigation, we have not challenged the validity of simply the basic permit to acquire. What we are implementing is these two extremely onerous requirements.
So what's the standard for judging the onerousness of it, because it doesn't seem to me that, or tell me if you think I'm wrong, it doesn't seem to me that that inquiry is a historically based inquiry. It seems to be a footnote 9, assess the burdens, and the only hint I see from footnote 9 how to do that are references to First Amendment cases. And so my question to you is the same as to your opponent, which is, do we look to First Amendment standards for assessing whether something is too onerous? We have tests in the permitting context in the First Amendment where it's a combination of the sort of time, place, and manner restrictions and then special restrictions about permits, about discretion, length of time. Would those be the kinds of doctrines we would now carry over for assessing background checks?
No, Your Honor. I believe I think it was Judge Sykes on the Seventh Circuit actually recently in a felon possession case referenced the Second Amendment as now a supercharged right post-Byrne. And as a supercharged right, Diana Sykes from the Seventh Circuit. And I think just going with what Judge Sykes was saying, the Supreme Court very clearly has said that First Amendment doctrine, the interest balancing, which is part of First Amendment doctrine, simply isn't applicable here. So I would suggest this court do.
But the whole comment in Bruin that the categorical approach applies and that interest balancing is out is done entirely by reference to First Amendment cases, saying we have historically based categorical exceptions from the First Amendment, and that's where they draw the analogy. So if they're getting that rule that we have to have historically based tests from First Amendment jurisprudence, why would this other aspect of First Amendment jurisprudence apply, especially when in footnote 9 they again cite the First Amendment?
As an initial matter, I was surprised I'm discussing the First Amendment in front of you again, Judge Collins. But no, I mean, this is why. What we need, I think the better approach to apply Byrne accurately is to demonstrate that, is you look at the historical burden. Okay, so you have a regulation that achieves purpose at 1791. Now you've got a modern day law that achieves the same purpose. We look to see whether this law has the same burden that those historical laws were. And here's an example of that. In Jackson v. San Francisco, Judge Ikuda discussed the gunpowder storage requirements. That's an example of how you can analogize properly to colonial laws and that achieve the same purpose.
There's not going to be any colonial laws about background checks because they were technologically infeasible. And so now that we've got this new tool, given we live in a more advanced technologically society, we've now got this new tool for implementing the historically based prohibited persons category. And so now we need to evaluate how the tool can be used. What are the standards for that? It can't be history because we can't get it from history. It didn't exist.
What I'm suggesting is that we look and see if a modern-day regulation has a comparable burden to something that 1791 achieved the same purpose. And this is the difference, what we're dealing with right now, and say the instantaneous background check that this court's alluding to right now. What's the burden of going into a gun store, filling out your 4473, and having an instantaneous background check? I think that's something that during the colonial era, I don't think anyone would have said, a very short, 20-minute delay is anything that's really burdening my ability to go pick up a firearm. Here, this is much distinguishable because we have the system that is hindering your ability to actually acquire a firearm. So
Your understanding that if a Hawaii citizen buys a firearm from an FFL, that they go through two background checks, one for the permit and one at the FFL?
Yes, Your Honor.
Okay. But as to those who don't buy from FFLs, the permit is the only background check?
I believe so, yes, Your Honor.
Okay. So then the permit does seem to be tied to the background check process, and then it's just a question of, is 10 days too much of a burden?
That's one way of looking at it, yes. I mean, yeah, I mean, when you go, yeah, the background checks with the permit to acquire, Your Honor, when you go for the first time.
Okay. And so how do we, in your view, assess, what are the legal standards for assessing the burden of the 10-day versus another period? What's the doctrinal formula that we use for that?
Well, I mean, I think as I said, I think that what we do is we look to comparable burdens during the appropriate historical era. You know, I think that's being 1791. And, you know, we look, you know, for example, we could look to the gun storage law. I'm sure that there were other comparable things that you had to engage in that when dealing with large amounts of gunpowder, say in Boston, and, you know, whatever that, you know, permitting process is, you know, you can apply something similar to that with a similar amount of difficulty to the modern laws. Again, so the issue I'm having in St. Pacifics is ultimately, though, the burden, the duty is on the state of Hawaii to produce those historical analogs. They just simply failed to do that here. They've listed 3 things, none of which are in any shape, way, or form close to.
3 things they used, at least with respect to the 10-day provision, are all related to justifying background checks, but we seem to all agree that background checks are not called into question by Bruin, and it's just a question of what Bruin tells us are the standards for assessing the burden involved in the background check process in footnote 9, and I don't see that that's historically based.
I mean, again, I disagree. I mean, Bruin makes it very clear that you need to they need to produce affirmative historical data. And I think the best way to interpret this is to look at the comparable historical burdens at 1791. And that's how you demonstrate analogousness. You know, another case where the courts use analogical reasoning, TransUnion v. Ramirez is a standing case, and they were trying to determine what was concreteness and they looked to see what is happening at 1791. And I'm saying is that what the court should, first, obviously, we believe the court should strike these 2 laws. And doing so, the methodology this court should employ is one that says the burden is on the government to find a comparable burden at 1791. And I think that if this court would do so, that would not be putting in danger instant background checks. It wouldn't be putting in danger the vast amount permitting in the continental United States. Because, you know, at 1791, I really don't think that the historical record would say that anyone would have an issue of going in, you know, for 20 minutes to wait for 20, 30 minutes on a background check. In fact, I point to this court's opinion in Texera, where they talked about the long delays in acquiring a firearm just simply due to the logistical issues associated with that. And, you know, I think what this court should be doing, right after Barron, right after getting rid of the interest balancing, I think we have a duty to take the Supreme Court at its word and, you know, not, you know, just simply come about and, you know, come up with another form of interest balancing just because that's something that is convenient. I mean,
what should we do with Justice Kavanaugh's concurrence in Bruin? I think the Chief Justice joined that. Is it just ignore it as a non-binding concurrence, or does it provide some guidelines for us?
Yes, Your Honor. I mean, I think that all Justice Kavanaugh is saying is, here are a list of things that still would be constitutional, in my opinion, afterwards. And, you know, I mean, he didn't say that to change the methodology that need to be employed from the majority opinion. This is just simply him stating that, the world's not going to end post-Mirren. Here's a list of things that, based upon my analysis, are not going to change. That doesn't mean that we need to import First Amendment doctrine into this.
Can we talk about the registration provision? So as this case comes to us, you're not challenging the requirement that they register the gun and provide a serial number?
No, I am not, Your Honor.
Okay.
Yeah.
So what do you understand to be the valid basis on which that registration requirement is based?
That's not something that we formulate an opinion on in this litigation. I mean, we're solely dealing with the two.
I know, but you're not challenging it, but yet we have to assess a restriction or a burden that arises in connection with it, and it's kind of important in assessing that burden to know what it is that justifies that system, and you concede that it's justified or you're not challenging it. What is that based on? What is the interest that's at issue in the registration side of it that ties it to a historically based category that we then can assess whether this is an inappropriate response?
Well, I mean, if we're talking about basic registration itself, I mean, the bottom line is that during the colonial era, there were people that were prohibited from owning firearms. I think Judge Bumate's dissent in the Azri-Mai case discusses a large history of mentally ill people, felons, of course, or at least violent felons or common law felons. And I think that that's what basic registration is doing, is making sure that you could justify that because it's not a big burden to compare to the colonial era. And
so you see the registration requirement as being tied to the prohibited persons rationale?
Yes, Your Honor.
How does it further that?
Well, it's it's just tied in with the background check provisions, Your Honor. Yeah, it's. I'd like to just very briefly discuss a remand. Remand was unnecessary in Bruin, and that was on a 12b6. And my friend on the other side suggestion that this needs to be remanded in order to develop a better record is just not accurate, especially in light of the fact that this was on summary judgment and there was a very wide historical record that Judge Seabright actually expressly issued a ruling on. So are there any further questions, Your Honors? I'll cede the rest of my time. Thank you very much.
Okay. Thank you, counsel. I'll give you 3 minutes for rebuttal. We took a lot of time with questions, but I'll give you 3 minutes.
Thank you, Your Honor. Your Honor, I believe we are on the same page on this. I think the court is wrestling with a very important issue. What's the basis for a lot of these concepts? And I think it's clear that militia laws provide some historical analog, especially for registration, for instance, but also this idea of historically grounded prohibited persons. This issue has really been litigated a lot. And there are historical bases for prohibiting certain people from having guns. There's the civic virtue theory. In the common law era, certain people were deemed to be unvirtuous citizens, and so they couldn't own guns. And a lot of Second Amendment scholars have explored that. There are a lot of cases that have relied on it. The Vongse case in the Ninth Circuit, Yancey, Binderup, and then Justice Amy Coney Barrett also explored this idea. She modified it a little bit. She said it's more dangerousness, not so much civic virtue. But regardless of what your theory is, it's clear that there is a historical basis for prohibiting certain people from having guns. And that's what our law does. These two laws, they try to prevent the criminals and the mentally ill from having guns. And it's done through certain procedural mechanisms. And as Justice Kavanaugh pointed out in his concurrence, these procedural mechanisms are okay. You know, fingerprinting, background checks, training programs. They have to be okay. Otherwise, you know, in the modern world, you couldn't stop certain people from having guns if they're dangerous. So I think what the court is wrestling with is very, very important. And again, if the court wants to remand, we can explore this with the district court. If not, I think the court, Your Honors, I think you're looking at this in what I believe is the correct way. And so the question is, you know, what kind of standard do you impose for these procedural mechanisms? Well, I think what we're left with is footnote 9. Footnote 9 says narrow, objective, not for an abusive purpose. I think we're stuck with that. And, you know, in dealing with whether this is for an abusive purpose, I think you have to consider what the purposes are. And I've explained the purposes of these procedures, and I think they are legitimate. They are not abusive. And based on that, you know, I would argue that the court should affirm these procedures because they're not abusive, and they're also narrow and objective. So based on footnote 9, Your Honor, I think the argument is very strong for upholding these procedures. If not footnote 9, look at the direct analogs, the militia laws, the pardons, the loyalty oaths. But either theory that the court, you know, accepts, I think they're legitimate theories, and I think they support our laws. Thank you, Your Honor.
All right, thank you. I'd like to thank both counsel for your very helpful arguments in both of these cases. And the case just argued is submitted, and we are in recess for today.